On April 11, 1961, the trial of Senior SS-Officer Adolf Eichmann opened in Jerusalem. He was accused for his role in the Shoá, the extermination of over 5 million Jews during German National Socialism.
I know that was a long time ago, and today we have other problems. But there are good reasons to report on this trial. First,
this trial, after the Nuremberg trials, was the most spectacular. Films, books, and dramas have been fabricated.
It's February 2021, and I'm sitting in my office in Buenos Aires. The media will use the 60th anniversary as an opportunity to celebrate the trial as the trial of the century, as a landmark for justice and human rights. Critical voices were and are hardly heard. I therefore ask, is the Eichmann criminal case a reason to celebrate or a reason to be ashamed? What do we know today? Who pulled which strings? Behind the scenes, in Jerusalem and in Pullach, the seat of German External Intelligence Service BND. Secondly,
was it a fair procedure with the rule of law? Did the court have jurisdiction at all? Was the public allowed to attend? Was there equal opportunity for the defense? Was the evidence taken comprehensively? And was exculpatory evidence also sought? Was the verdict balanced, or was the punishment fixed from the outset?
A dictatorship does not need public trials, at the best, show trials. As trivial as it may sound, a reasonably independent juridical system is an expression of a civilized society, especially when it comes to punishing serious crimes. Judges, but also journalists, need to keep the people that they evaluate at distance. We must not allow ourselves to be crushed by morality. This is not a denial of solidarity with the victims, but we must take a sober look at the facts. It is not acceptable to say the accused somehow deserved it, because there is no doubt about it. Eichmann actively participated in the deprivation and extermination of the European Jews. Such people must be held accountable. The question is, how? Thirdly,
Eichmann's arrest in Argentina and the trial in Jerusalem have influenced the global discussion on human rights. Since then, it has been true that even masterminds can be convicted as murderers. And it is true that genocide is a crime against humanity, and that these crimes can be brought to trial anywhere.
I was too young at that time, but for my generation, the kidnapping and, as we believed at the time, the conviction of a Nazi criminal under the rule of law were important. We concluded that laws may be transgressed if a higher good requires it. Justice is above simple laws. Today, I wonder if we debated on the basis of a lie fabricated by the intelligence services. And fourth,
Israel is using the Eichmann case to flout international agreements. In order to break impunity, Argentina's sovereignty had to be violated. But did the Mossad and Hollywood tell us what really happened?
I have been suing for the release of the Eichmann files for many years against the Argentine Foreign Ministry, the German Federal Intelligence Service, and in Russia. Only in Israel, everything is closed. In my opinion, the Eichmann case is the mother of all fake news. We must study it to defend our right to truth.
The BND had just delivered me another batch of files. Not everything yet, but the new lawsuit has been filed. We are well on our way.
Today, it's not about the kidnapping. I have made several documentaries about that. It's about the trial. Here is a brief history.
Like thousands of Nazis, Adolf Eichmann traveled to Argentina in 1950 with forged papers, and 2 years later, his wife and sons arrived. They lived there under their real names. in 1956, the Frankfurt prosecutor's office issued an arrest warrant. But Interpol refused to execute it, and the Argentine military kept its protective hand over the Nazis. On May 11, 1960, Eichmann did not come home from his job at Mercedes-Benz Argentina. And on May 23rd, Israel's Prime Minister David Ben-Gurion surprisingly announced his arrest and the opening of a trial.
There are two versions about these 11 days in Argentina. The official one of the State of Israel, which speaks about the heroic search of the Mossad. This version is in the history books. The only evidence for this version is the narrative of the intelligence chiefs. The archives are closed for reason of national security.
Those of the Mossad, anyway, and also those of the Prime Minister, his office told my Israeli lawyer. And even what was already stored in the National Archives in Jerusalem has now disappeared.
Historians and journalists must not trust the fables of secret services, as pretty as they may sound. History needs official documents, and this is why, as I said, I went to court. Everything else is a conspiracy theory, fake news. In the meantime, I have a lot of official documents, and they show a completely different version, also regarding the trial of the century in Jerusalem.
When Eichmann appeared in Israel captivity, the first question was, why should Israel have jurisdiction, and what other judicial authorities have access to the accused? Usually, territoriality is crucial. Where did the crimes occur? And which authority investigated? Most arguments were in favor of Germany. There was an arrest warrant from the public prosecutor's office in Frankfurt, and the German embassy in Buenos Aires had tried to have it executed. The evidence was in Frankfurt, and in Frankfurt was the chief public prosecutor, Fritz Bauer, a social democrat, of Jewish origin and an anti-fascist. He later presided over the Auschwitz trial. The perpetrators had been Germans. The exterminations of Jews had been ordered and carried out by the German Reich government. Among the victims were thousands of German Jews.
A trial in Frankfurt would have forced West German society to stop hushing up the subject of the persecution of the Jews. It would have triggered a political earthquake, including over the question how many former Nazis sat in the administration and government. The most important one, Hans Globke, commentator of the Nuremberg racial laws, and in 1960, Secretary of State in the Chancellor's office. But Ben-Gurion was negotiating with Konrad Adenauer for a 3-digit million sum for his nuclear program. He saved the German Chancellor from this debate.
The German government did not lift a finger to put Eichmann on trial in Frankfurt. On the contrary, it gave the BND the task of preventing public figures from being mentioned during the trial in Jerusalem. Thus, the service in Pullach established contact with the Israeli Secret Service. The Blue Partner, Bluestar, or Bluestar, were the cover names for the Mossad. They called Adenauer Fixstern and Globke Globus or Erdball. BND had emerged from the Gehlen organization and was headed at that time by Nazi General Reinhard Gehlen. He appears in the BND papers as 363. He had recruited the old comrades who had learned their business in the SS and Gestapo. But with their colleagues from the Blue Partner, they got along brilliantly, the files reveal.
Conversations with Fichten and Gideon gave the impression that Bluestar did not intend to attack the Federal Republic in any way in the course of this process. Rather, a strict distinction is to be made between the old and new Germany. Bluestar fears that the Soviet bloc may extend its anti-German propaganda to German-Israeli cooperation.
Like Fritz Bauer, Eastern European countries also wanted to prosecute Eichmann. Especially in Poland and Hungary, the Nazis had raged against the Jewish population and established extermination camps. Eichmann was to be extradited to Warsaw. the BND feared after the appeals court ruling.
The defense presented a plea for clemency. Others were available. Bawa asked the Israeli government to allow the defendant to be interrogated in the course of some German concentration camp proceedings. Similar requests had been received from Yugoslavia, Poland, Czechoslovakia, and Argentina.
But Ben-Gurion had the convict executed immediately after the case became final. In this way, he blocked the way for investigators from other countries to obtain information that would have led to the arrest of other war criminals.
Israel did not exist at the time of the Shoah. There were survivors there, but not a single prosecutor had taken an interest in prosecuting Nazis before May 1960. There were no investigations against Eichmann or anyone else. The argument against Israeli's jurisdiction was that some defense witnesses would appear in court only with assurances of free passage, but this was refused. The president of the World Jewish Congress, Nahum Goldman, proposed the establishment of an international court based in Israel but with judges from various countries. Ben-Gurion was outraged.
To US President Eisenhower, Ben-Gurion had promised in May 60 a diversion for his fatal nuclear tests in Argentina. And to Adenauer, Ben-Gurion had promised in March in the conversation on German support for his nuclear program not to put this issue on the agenda, either at home or internationally. So, he had to control the entire process.
The Israeli judicial authorities invoked the Nazis and Nazi collaborators punishment law of 1950, which until then had practically never been applied. The young state had other priorities. The judgment was based on specific character as being designed to exterminate the Jewish people. The victim nation has the right to try any who assault its existence. Israel cannot be cut off from its roots, which also lie deep within the Holocaust of European Jewry.
Let us take an extreme example and assume that the Gypsy survivors, an ethnic group or a nation who were also, like the Jewish people, victims of the crime of genocide, would have gathered after the war and established a sovereign state in any part of the world. Then it may make use of such sovereignty for the enforcement of its natural right to punish the offender who injured it.
It is not a natural right, but law that determines the place of jurisdiction. But even if we affirm Jerusalem's jurisdiction, who gave Israel the right to deny the Eastern European states and the Frankfurt Prosecutor's Office their sovereignty for law enforcement?
Ben-Gurion overrode all objections. Although already agreed with the Frankfurt prosecutor, he prevented Eichmann from testifying to Bauer about other SS officers by hanging him immediately. In the international human rights discussion, the Eichmann trial is celebrated because it introduced the principle of crimes against humanity. According to this principle, crimes against humanity can be tried anywhere in the world. It was later invoked by prosecutors of South American dictators who were not prosecuted in their home countries because of amnesty laws. The establishment of the International Criminal Court in The Hague is also based on this principle.
This is not wrong, but too easy. After all, the movement against the impunity of South American torturers has shown that juridical processing on the ground must come first. And against Eichmann existed, after all, an arrest warrant, evidence, and a competent prosecutor in Frankfurt.
Equality of opportunity between the defense and the prosecution is the basis of a trial under the rule of law. Today we know that the secret services pulled the strings. The Mossad handed over the complete transcripts and 76 audio tapes to the BND. Mind you, the organization of Nazi General Gilden.
We had at our disposal, now without blackening, 3,564 pages of transcripts of Eichmann's interrogation in Israel.
Together, they prevented lawyers from the Eastern Bloc from influencing legal proceedings. Lawyer Friedrich Kaul had arrived from East Berlin and presented powers of attorney of Jewish victims. Promptly, a new law was fabricated.
From Tel Aviv, it is reported that the Knesset had approved a special law that makes the participation of civilian joint plaintiffs in the trial impossible. This means that Kaul cannot be a joint plaintiff.
During the trial, German newspaper Bild broke into Kaul's hotel room and stole documents that were sent to Pullach. This document did not come from the BND, but from the archives of the Foreign Office. A lawyer from Chile wanted to take over the defense, allegedly for nothing. Does he have connections to neo-Nazis or to left-wing extremists, they asked in Pullach. They checked him for connections to the East, but all they found in his Munich apartment was a picture of Hitler. A team of lawyers from England wanted to join the defense. The BND checked and came across suspicious things, namely that
it is skeptical of Zionism.
The lawyers Gustav Heinemann and Dieter Pusse came into play. Heinemann later became president of Germany and Pusse Minister of Justice in North Rhine-Westphalia. But they were social democrats and also defended communists, so totally unacceptable to the BND. The Eichmann brothers suggested the lawyer who represented Hitler's sister, also too opaque for the service. He wanted to control the defense and not deal with the family. How convenient that there was a lawyer in Cologne with whom the Secret Service had already been working since September 1955.
Dr. Servatius hoped to use cooperation with our service in order to enter in consular service. In order to obtain the mandate, he contacted Eichmann's brother and met with him for an initial meeting in Salzburg.
Servatius discussed his legal steps with BND. Agents accompanied him to Jerusalem.
Undercover Agent 7461, codenamed Laguerre, is to accompany Servatius and travel to Cologne to apply for a visa there.
Pullach was in close contact with Blue Partner and provided logistical assistance.
On 16 January 1961, a secret meeting took place in Munich between the assistant of the lawyer Servatius and a member of the Israeli Security Service. He was to determine whether the assistant himself had been involved in anti-Jewish measures through his family.
It was Dieter Wechtenbruch, born in 1931, so he was 13 years old at the end of the war, BND reported.
Further observation is assured.
The defense lawyers overrode the declared will of their client. The BND and the Federal Chancellery were determined to avoid mentioning Secretary of State Globke in the trial. 2 weeks after the opening, Gillen learned.
Servatius was asked by the Israeli Public Prosecutor's Office about a document from January 1941 referring to citizenship in the Greater German Reich. On the attendance list, Dr. Globke named appears, head of Department of the Reich Ministry of the Interior. Servatius is said to have replied that he was just as uninterested in bringing up domestic German problems in the negotiation as those of Israeli domestic policy.
The Israeli problem was Eichmann's cooperation with high-ranking Zionist officials.
Servatius presented this document to his client, who commented,
The officials of the Reich Ministry of the Interior were tightened the meshes, and the Gestapo had to work according to it. One of the wire pullers at the time, who created the legal keystones to make the Jews lawless, sits today as undersecretary in the federal government.
In the BND files, there is the ready formulated request for evidence of Globke's interrogation. This time, the Israeli prosecutor pressed him.
Hausner stated that the defense should interrogate this witness in the Federal Republic after all. Servatius acknowledged these arguments.
In February, shortly before the opening of the trial, Eichmann was interrogated in jail about Globke. He refused to testify because of Servatius' instruction. The lawyer delivered the family's letter in Pullach.
Enclosed are copies of the brother's letter to Dr. Servatius.
He informed about his trips to Israel and handed over his correspondence with the Israeli Minister of Justice. The Secret Service took care of the financing of the defense and reported to Globke personally, and he sent material written by the Undersecretary to the Mossad, to Bluestar. Globke knew that Servatius would be rewarded by private sources, apart from the $20,000 that Israel paid to the lawyer, according to the agreement Eichmann had made with the Israelis while still in Argentina.
Attached is submitted the following report for Globos information. Measures taken against the live publications of the Eichmann memoirs and status of litigation financing. Until today, no direct or indirect payments have been made to Dr. Servatius by federal agencies.
The lawyer planned to seek an injunction against the federal government for paying his costs, but it failed before the administrative court. Eichmann was not a German citizen and had evaded the authorities by fleeing.
Speaking of citizenship, it is proper that it is mentioned in the indictment and in the verdict, but it is missing.
The reason for this we now learn from the BND files.
Many secrets in the trial of Eichmann. What citizenship he possessed at the time of his capture is to remain a state secret.
Eichmann, while traveling in Palestine for a U.S. oil company in the 1920s, had used a forged birth certificate stating that he was born in Haifa. Under German law, a national automatically forfeits his citizenship if he adopts another.
Legally, therefore, Eichmann was stateless, or Israeli, if we take the birth certificate from Haifa as a basis. This was hidden in the trial.
Attached is submitted a top-secret report about the confidential conversations between Servatius and Eichmann. Eichmann's statements are likely to be of the greatest interest to the Undersecretary in the Chancellor's office.
In other words, the meetings between lawyer and client in jail were recorded in Israel and forwarded to the BND and the German Chancellor's office.
Eichmann is said to have initially claimed not to know Globke personally. Ben-Gurion explained this to an emissary of the Chancellery in February 1961. Even before the trial began, the BND fell for the idea that Eichmann should call himself a communist in court. Servatius convinced his client to do so. After all, he had nothing left to lose. He wrote to his brother. Agent 7396 reported.
Servatius handed me his entire letter. I explained to him that under no circumstances could he leave it to the provincial family members to decide whether or not this part of the letter should be made public. At my suggestion, the letter was transcribed by me and the declaration for the Eastern Bloc was withheld. Only 2/3 of the letter was given by Servatius to the brother in my presence.
The BND distributed his letter to selected media, but in the end, the plan was not carried out. CIA Chief Allen Dulles was against it. The plot of the BND and the Chancellor's office worked.
Eichmann's closing statement originally contained the name of Dr. Globke. At the instigation of Dr. Servatius, it was then struck out and no longer mentioned by him in the closing words.
The fact that the West German administration was riddled with former National Socialists was not an issue in Jerusalem. In December, the verdict was sentenced, the death penalty.
We therefore convict the accused. He, and in collaboration with others, caused the deaths of millions of Jews, with the purpose of implementing the plan which was known as the final solution of the Jewish question, with intent to exterminate the Jewish people.
The Israeli justice system, however, did not pursue these others, the accomplices.
Eichmann had trusted his lawyer and expected a prison sentence. Now he felt betrayed and was determined to mention Globke in the appeals proceedings.
At the first possible opportunity.
Panic broke out in Pullach. The lawyer immediately had to calm his client down.
Servatius reported on his trip to Israel from December 28 to January 8. Eichmann intends to cooperate eagerly in the appeals proceedings in order to correct the errors and to present the actions of those responsible who work with him on equal rank or as superiors in other departments on the final solution of the Jewish question.
He commented on the verdict in a 140-page transcript, naming Globke again and again.
Eichmann was prepared to answer questions at any time during interrogations in the Federal Republic.
On March 11th, Servatius went to Jerusalem again,
with the intention of naming Globke at the appeals hearing.
Almost regretfully, the lawyer told the BND.
Even if he abstained from naming him, Eichmann would press for it at the first available opportunity in court.
Eichmann's detailed statement had already ended up in some media, he said.
Dr. Globke must now be heard as a witness. In Jewish affairs, Dr. Globke was responsible. The Reich Ministry of the Interior was the central office for Bohemia and Moravia. Stuttgart was the head, Globke his referent for racial matters.
2 days later, the BND gave the all clear. Against his client's wishes, Servatius did not mention Globke in the grounds of his appeal.
For the first time, the extermination of the European Jews was tried in a civilian court in Israel, and all the world was convinced by the sensational kidnapping story from Argentina and hoped for details. Adenauer feared that the young Bond state would sit in the dock.
Ben-Gurion reassured him.
The Israeli government had no interest in the trial being turned into an anti-German propaganda showpiece. Referring to the world public, however, one could not avoid organizing the trial in such a way that it would be generally recognized as a fair and correct one. This requires a certain minimum of publicity. Photo and television reporters should be admitted only once before the start of the trial. Later, there would be only one closed and glazed cabin for photo and television reporters, and only Israeli government photographers and the representatives of the television company with which a contract had been signed would be admitted. Through this centralization, it is hoped to achieve a restrictive effect.
Despite these restrictions, the turnout was tremendous. How could the coverage be controlled?
How the Mossad put the Israeli reporters under pressure can only be guessed. Its files are secret. But we know now how it checked the German journalists by the BND.
And the BND dutifully delivered, in cooperation with the Office for Internal Intelligence. For example, Konrad Allers, then editor of the Frankfurt Rundschau, later federal press spokesman for the SPD, the Social Democratic Party.
Nazi past not recorded.
There were no negative findings about most of them. But there was the Sturzenbach, high member of the Communist Party.
The majority of reporters are younger journalists, without a Nazi past. With the older ones, there are no details.
The Israeli authorities could have seen the age from the accreditations, but it was probably a matter of discovering critical spirits. The Chancellor's office asked Gelin what he knew about the cameraman Helmich. Answer: he worked for the Soviet Zonal DEFA. It meant Socialist Germany.
Instruction is requested. Weather warning Bluestar against Helmich.
Then it was the turn of the chief reporter of the Welt.
Inquiry Bluestar. Answered by telephone.
He had an allegedly left-wing brother. Candidate number 2, Clamp on Jew, was expelled from England after the war.
Answer given to Blue Partner. Referring number 5. Old member of Communist Party sentenced to 6 weeks in prison for putting up posters.
The BND fed information to selected newspapers. Thus, it learned from Stern magazine that a contract between Mrs. Eichmann and Life magazine had been sold to the Israeli intelligence service. It concerned a manuscript and tapes that had been made in Argentina 3 years earlier, the so-called Sassin Protocols. The BND promised the weekly review exclusivity to Eichmann's Confession of Communism. The Foreign Office wanted to send its own representative to Jerusalem, attorney von Preußen. The BND and the Chancellor's office were horrified. relations between Pullach and the Foreign Office were never particularly good. When Eichmann had named the ambassador in Roman a Nazi during interrogation, which the Mossad immediately leaked to the BND, he kept his information to himself.
Because of source protection, we refrained from submitting it to the Foreign Office.
And now, the Foreign Minister wanted to be informed by his own hand from the courtroom.
Do we know anything about von Preußen?
Undersecretary Globke even spread the rumor that von Preußen had a membership number of the Nazi Party. After Eichmann's execution, the BND was supposed to write a final report on the impact of the trial in German-Israel relations. It was not written by itself, but obtained by von Preußen's material via a spy.
The records were temporarily made available to T1P's field agent, Bernard, by Mr. von Preußen, with whom Bernard is friendly. Of course, Mr. von Preußen knows nothing about Bernard's activity at our service. Therefore, B asked for particularly confidential treatment.
The purpose of criminal proceedings is to establish the truth. The evidence must be complete, accomplices must be identified, and exculpatory material must also be presented.
Ben-Gurion wanted a short trial. Things that would have caused him domestic problems were to be excluded, such as the Hungarian complex in 1944, and the German government wanted to prevent any mention of accomplices. Globke, but also Eichmann's former superior in Hungary, Kurt Becher, a high-ranking official of SS, who had become after the war a wealthy businessman in Bremen and maintained good relations with Adenauer's House Bank. The BND feared
that Becher would be blown up in connection with Eichmann and that, with him, business connections would be blown up. He was Eichmann's right-hand man in Budapest and is now financed by the Vermögens Bank. He has just left for Argentina. Becher would have to fear being incriminated retrospectively by the Eichmann trial, although at the time he was extradited to Hungary as a war criminal but released in Budapest.
Becher owed his release to the testimony of Rudolf Kastner, a Zionist official in Hungary. In Israel, he was later suspected of being a Nazi collaborator and shot in the streets. Ben-Gurion pardoned the murder after only 3 years in prison. Eichmann wrote about him in prison. His report ended up in Pullach via Bluestar.
It was Kastner's main concern to enable a select group of Hungarian Jews to emigrate to Israel. He would have sacrificed hundreds of thousands of his blood brothers to achieve his political goal. He had no interest in all Jews or in those who had been absorbed by the Hungarian society. But with incredible tenacity, he tried to save biologically useful Jewish blood, human material capable of reproducing and doing hard work. Because Kastner did us a great favor by helping us keep calm in the deportation camps, I let his groups escape.
Hannah Arendt was one of the few critical trial observers. The Jewish philosopher reported for The New Yorker, also on the collaboration between Zionism and Nazism. German journalists remained and remain silent on the issue. Arendt.
Kastner saved 1,684 Jews and extradited 476,000 Jews.
In Israel, Arendt was publicly insulted for her lack of love for the Jewish people and her alleged Jewish masochism.
BND worried about an article from the Daily Herald.
The writer, Czech doctor and Jew Verba, accused Ben-Gurion of having paid Kastner several $1,000s for rescuing his family. Kastner rescued all of Ben-Gurion's relatives.
However, the topic Hungary could not be kept out of the trial, and this was mainly due to the author of this book. In it, the head of the Jewish community in Budapest, Joel Brandt, had told of the offer that Eichmann had made him in 1944 on Himmler's order. He would let 1 million Jews, instead of sending them to Auschwitz, emigrate, in exchange for the delivery of 10,000 trucks. And Brandt was determined to testify this in Jerusalem.
The BND cared. Report to Gehlen.
Source was visited by Joel Brandt. The prosecutors have instructions from Ben-Gurion to keep the hearing lean. Ben-Gurion has begged Brandt in a letter not to appear as a key witness because otherwise he would be cross-examined by the defense.
In 1939, Eichmann had headed the Central Office for Jewish Immigration in Vienna and forced immigration. His methods were brutal, but objectively he saved thousands of lives. Eichmann to Servatius.
I was condemned because I ran the immigration. The Interior Ministry obstructed it. Who acted more correctly under the given circumstances?
If he had done nothing,
no Jew would have come out of the concentration camp and emigrated at the time, and the incoming foreign currency would have been appropriated by the Reichsbank.
The prosecutors accused Eichmann of the deportation of Jews from Baden to the south of France, which he ordered in October 1940. The judges convicted him for this.
We have found that these deportations were organized by the accused in complete disregard for the health and lives of the deported Jews. There is no doubt that here there was cruelty which bordered on premeditated malice. Therefore, we shall deal with these inhuman acts as being crimes against humanity.
The defendant commented this so.
Otherwise, these Jews would not have reached freedom, but would have been taken to a concentration camp. A return to their homes in Baden was impossible, since housing and property had already been confiscated there.
Hannah Arendt had criticized that the prosecutors did not seek exculpatory material. They could have called the witnesses who had known Eichmann as an immigration expert. He had worked closely with the Zionist messengers who had arrived from Palestine and who were looking for usable material for immigration in the German Reich.
Thus, he saved at least 50,000 Jews in Vienna who otherwise would not have survived the Third Reich. These officials of Aliyah Beth could have been named as witnesses since they lived in Israel. It was omitted.
In the post-war Germany, the extermination of Jews was not an issue for a long time. Even at the Nuremberg trials, it was mentioned only in passing. This had changed with the publication of Joel Brandt's book in the mid-50s. This put the Nazi exile in Argentina in need of explanation.
The former SS man and journalist Wilhelm Sassen interviewed Eichmann about this for months in Buenos Aires. The so-called Sassen protocols consist of over 700 pages. They were secret and only released in 2011 during my trial before the Federal Administrative Court. But the BND and Mossad already had it before the trial in Jerusalem began. So did prosecutor Hassner, and he quoted from it in court, but it was not admitted as evidence.
Why? I suspect because then the thesis of Eichmann's role as quasi-creator of the final solution would have been hardly tenable. Hannah Arendt had called the defendant a Hanswurst, a fool, and Sassen, the SS officer, detested him. Quote from the interview.
You ridiculous Pimpel. Did you fight at the front?
He hadn't, not a single day. During the war, he sat in the warmth of his office and wrote names of men, women, and children on transport lists, knowing what fate would await them at their destination.
This interview would have been important evidence. It was given freely in an internal circle. From it, we learn personal details about the defendant, such as that he could not see blood and that he got weak-kneed when visiting Auschwitz. He boasted that he let a cousin, a half-Jew, leave for Switzerland after she spent a night with him. Why wasn't it introduced in the proceedings? One of the reasons was that doubts about the defendant's Aryan ancestry would have arisen from the Sassen interview.
Eichmann was responsible for this within the Gestapo, he told Sassen.
On the instructions of my head of office, Heinrich Müller, I investigated the terms of ancestry of the Führer's diet cook.
Result of his investigation. She was a 32nd Jewish, but was lucky. Müller quietly took her file and treated it as a secret Reich matter. It was known that the Gestapo chief Reinhard Heydrich's grandmother's name was Sarah. Then the church records and her gravestone disappeared. And in the end, even the people who had put the information into the world. Eichmann said he would have done the same.
He had it quietly put right. I would have done the same to avoid misunderstandings.
He did the same thing. Eichmann would have had to provide complete proof of his Aryan ancestry back to the year 1800 when he joined the SS. He couldn't. Eichmann's genealogical chart is missing one crucial piece of information, his grandmother's religion. In the city archives in Wuppertal, where the documents about his ancestors are located, the birth and marriage certificates on which the religious affiliation would have been written are missing. In the Sassen interview, the Jewish Versippung, the racial mixture, was a topic. The BND, like the Mossad, thus knew of Eichmann's problem regarding his ancestry. In court, the mention would have been embarrassing. Liliana Hermann is Lothar Hermann's grandniece. I have already reported about his case in the film Disinformation. The Hermanns were Jews from Germany. Lothar was in the Dachau concentration camp. Almost the entire family was killed in Auschwitz and Buchenwald. Lothar fled to Argentina, as did his brother, Liliana's grandfather.
Lothar vivía con su familia acá en Olivos y en el 54 se tuvo que ir.
Y él denunció a su vecino que vivía impunemente, que era Adolf Eichmann, vivía con su nombre y apellido en el barrio, iba al almacén a comprar y todo y vivía impunemente y sus hijos también iban a colegios alemanes con su verdadero nombre y apellido.
Y él lo denunció.
Y él lo denuncia. En el 54 ya comienza las denuncias a la DAIA y a la Embajada de Israel.
¿Y qué pasó con las denuncias?
Y las denuncias, y no pasó nada, Gaby. No parecía no importarle las denuncias y bueno, él se tuvo que ir a vivir al sur de la provincia de Buenos Aires, a Suárez, Coronel Suárez.
In 1957, he learned from the press that an arrest warrant had been issued for his former neighbor, and he informed the Frankfurt prosecutor's office of his whereabouts. Nothing happened for a long time. Then, Eichmann suddenly turned up in Israel in May 1960 as a prisoner. Lothar Hermann knew that things had gone quite differently. In 1961, shortly before the start of the trial in Jerusalem, he sent a letter to the Israeli Minister of Justice and prosecutor Hausner, threatening to reveal the true story.
En 1961 irrumpen en su casa varios agentes del Estado de Israel, varios de Alemania federal, para amenazarlo, para que se calle la boca y bueno, y al rato le golpea la puerta a un periodista de un diario muy importante de Inglaterra, del Daily Express, y le dice: señor, ¿usted tiene información de Mengele? Le dice: no, salga de mi propiedad, salga de mi casa, le dice Lothar. Y bueno, se va el periodista a la comisaría y lo denuncia de ser Joseph Mengele. Entonces va la policía y lo lleva preso varios días hasta que la embajada alemana compara con las huellas dactiloscópicas de Lothar y no.
After that, Lothar Hermann remained silent. His name was not mentioned in the trial. In December 1961, the sentence was passed. Death by hanging. Servatius appealed, named further witnesses without Globke, although his client had expressly wanted this. The attorney criticized the illegal transfer of the accused to Israel and again disputed jurisdiction. The appeal was rejected. New witnesses were not heard. The defendant was executed immediately. And thus ends the BND file. The goal had been achieved.
Hannah Arendt had wondered about the obvious omissions of the defense attorney. Why had he not plead for a reduced sentence?
150,000 Jews had immigrated from Austria, many of them to Palestine. Eichmann had headed the immigration office at that time. Even the judges had to write that in their verdict. However, they did not consider this to be a mitigation of the punishment, but attributed a deceitful intent to him.
But this was nothing else but the beginning of the system of indirect rule, which the accused developed so cleverly.
Eichmann clever? Was he not the Pimpel to Sassen and the Hanswurst to Arendt?
The fact is that 150,000 Austrian Jews could immigrate and thus save themselves. Nor did the court want to hear that he had cooperated closely with Zionist officials, as he told Sassen, and was even invited to Palestine. The defense attorney could have put this in the balance and asked for lighter punishment.
The court must evaluate the circumstances in which the crime took place, which includes the personal situation of the defendant.
In his closing statement, Eichmann explained that he had to act on higher orders.
This argument is not sufficient for impunity, said Hannah Arendt, but it can lead to a reduction of punishment. The Nuremberg war crimes trial, after all, had also handed down various penalties. Could the accused have recognized the injustice while his entire environment accepted it? The verdict makes it easy.
The criminal decrees of Hitler and his regime are not laws and have been set aside with retroactive effect, even by the German courts themselves.
During the Third Reich, the laws existed, like the Nuremberg race laws. Eichmann had drawn up the transport lists according to the criteria laid down therein. The defense counsel could have pointed this out in order to spare his client the hanging.
Of course, Hannah Arendt did not know the BND files, which were only released through my trials. She would probably turn around in the grave. In any case, her book, Banality of Evil, is still very much worth reading today, even if I myself do not agree with everything. For example, with her harsh critics on the Jewish collaborators in the concentration camps. Yes, they were. They exist in every terrorist regime, where the fear of death determines everyday life and it is only a matter of bare survival. But does that only apply for the victims? In any case, Servatius could have raised this question. What alternatives Eichmann had, whether he acted out of fear of death. It is not a matter of pity for the defendant, but in what personal situation was he? Certainly, he could have left the Gestapo and been sent to the front. Not a pleasant perspective compared with his office job. Then someone else would have taken over his job as an ancestry checker and probably found out that he was not of pure Aryan descent. That would have been the end for the SS man. A perpetrator's mortal fear does not undo his crimes, but a lawyer can cite it as a mitigating circumstance. Servatius failed to do so. The BND was grateful to him for that. So was Ben-Gurion.